A winding up petition represents the most serious action a creditor can take against your company. It will typically be the last step of a sustained yet unsuccessful effort to recover payment from your company for monies owed. This is a costly process for a creditor to initiate, and you should see this as a serious statement of intent to force your company into liquidation. If you ignore a winding up petition, you run the very real risk of seeing your company forcibly wound up and its assets liquidated by order of the court. If you have been issued with a winding up petition, all is not lost, but time is very much of the essence. Once the petition has been served, you only have a limited amount of time before the situation becomes public knowledge, at which point your bank and other creditors are likely to become aware of what is happening. Once this happens, you can expect the bank to freeze your accounts, which is likely to force your company to cease trading. Depending on the financial position of your company and the likelihood of affecting a successful turnaround of its fortunes, there are steps you can take to postpone the winding up petition and avoid a compulsory winding up of your company. This may involve entering into formal negotiations using a CVA or applying to the court for an adjournment while the company's financial position is reviewed fully. A licensed insolvency practitioner will be able to assess your situation and advise on the most appropriate course of action for you and your company. In some cases, the company's financial problems will have taken it beyond the stage where a turnaround attempt is likely to be successful. If that is the case, we can talk you through placing the company into voluntary liquidation rather than have this forced upon you by the courts with a winding up order.